Welcome to this edition of Real World White Collar Law, where we talk about real world issues in the white collar field as well as those impacting businesses. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard.
And I'm David Deitch, also from Berenzweig Leonard.
Yes, David, you modestly, you head up the white collar law practice here at Berenzweig Leonard. Talk a little bit about that before we jump into this case.
Well, Berenzweig Leonard is a business law firm, and businesses face a whole number of challenges that sometimes impact white-collar criminal law, and I'm here to help.
Okay, so when people say white-collar law, white-collar criminal law, so you're not talking about, petty theft, you're not talking about violent crimes, things of that nature. White-collar crimes are usually seen a little bit more in the business context, correct?
That's right, and white-collar criminal law really the criminal part isn't exactly accurate either, because white-collar criminal law or white-collar practice really encompasses other things like civil enforcement by securities regulators or other kinds of regulators as well.
So today we're going to be talking about the Computer Fraud and Abuse Act. And we're here in D.C., the D.C. region. Everything's got to have an acronym. So we got the CFAA. We'll call it the CFAA today, but it's the Computer Fraud and Abuse Act. And it's recently gotten a lot of attention, particularly at the United States Supreme Court. Tell us why.
Well, the Computer Fraud and Abuse Act was passed in the 1980s really to get to the problem of hacking.
Did we have computers in the 80s? I'm trying to think. We had Saved by the Bell. No, I guess we did have computers, didn't we?
Well, we had computers, but the real problem is that it was a statute that was written when we had computers, but we really didn't have the internet the way we did. Yeah. And even if the internet kind of existed in the 1980s, it wasn't a pervasive part of our lives the way it is now. So the statute was really the statute was intended to get to the problem of hacking, but
computer hacking, we see it all the time. Yeah.
But the way it's been interpreted since then has gone dramatically broader. And that's the issue before the Supreme Court.
So it was passed. Congress set forth the language in the mid 1980s. Has it been updated? I know there was one amendment, a small amendment in 1986, but has it been amended in all of the decades since then?
Not in the part that's really before the Supreme Court. And there were really two parts of the statute. One talks about knowingly accessing a computer without authorization. Okay. That's easy. That's hacking, plain and simple.
Yeah, that's me. I have no business going into somebody's computer, and I'm somehow able to, the phrase is hack, I'm somehow able to hack into it. We're not talking about that today. We know that that's a crime that can find you in federal prison.
That's right. And the other part of the statute talks about when someone exceeds authorized access and then either gains information or alters or deletes information based on that access. And that's where we are today, is talking about what does that really mean to exceed authorized access.
So in other words, I'm allowed to be in this computer system, but what I do in that computer system is not really what I'm supposed to be doing it in. And the question is that against this Computer Fraud and Abuse Act, right?
That's right. And there's a split in the courts of appeals around the country. Some of them have taken a broad view of the statute, meaning that if you are on a computer and you use the information you gain from the computer for an improper purpose, for a personal purpose, for a purpose for which you were not authorized, then that is, in fact, a violation of the statute. But several other courts of appeals have reached the opposite conclusion, which is that purpose has nothing to do with it. If you were authorized, and it may be wrong, but it's not a violation of this federal statute.
And so one of the jurisdictions, we're here in Virginia, we're in the D.C. region, one of the jurisdictions that takes that view, the second view, which is basically, hey, as long as you're supposed to be on there, you can kind of do what you want. You still could be guilty of other things, but you're not going to be guilty of the CFAA. The Fourth Circuit, where we are, they take that view, as I understand it, correct?
That's right. And you brought up an important point, which is that we're not talking about whether it's right to use information from a computer for the wrong purpose or for an illegal purpose or even just a purpose that you weren't supposed to be using it for. We're talking about whether it's a federal crime and whether it can be used also by civil litigants in bringing a claim.
Yeah. So the case before the U.S. Supreme Court, it's the United States versus VanBuren. It's a criminal prosecution against a gentleman by the name of Mr. VanBuren, a police officer. Tell us a little bit about the background of that case.
Well, VanBuren was a police officer. And as a police officer, he had access to certain databases that were there for official use by the police department, by police officers. But in this case, VanBuren was paid some money from a friend to find out if a stripper was in fact a police officer.
It's always a stripper, David. Always a stripper that gets you in trouble here.
Well, yeah, certainly in this case.
That was a little bit of a pregnant pause there. I don't know. But anyways, okay, so he's allowed to get on there. His friend says, hey, here's some cash. Find out if this woman that I met, this stripper, is an undercover police officer. So he got on this thing. So two different ways that the courts have looked at this. One is, well, he's allowed to be on there, so what if whatever he does? So no conviction. Or the other earlier view that you talked about, he goes on it, but then he uses it for an improper purpose, which is spying on and finding out what this girl did. What was the result before it got to the U.S. Supreme Court?
Well, he was convicted in the trial court, and the Court of Appeals for the 11th Circuit upheld the conviction.
Okay, so they basically took that the earlier, they took the view, you talked earlier about there's a split in the circuits. They took the view of, hey, if you're on there, that's fine, but if you do things that are improper, you're going to be guilty under the Computer Fraud and Abuse Act.
That's right. So VanBuren filed a petition to have his case reviewed in the Supreme Court, and it has been reviewed by the Supreme Court. And in fact, they just had oral argument this past week. And his argument was that the statute bars only people who are not authorized to access the computer or the part of the computer involved. And here, VanBuren was authorized. He was a police officer. He was allowed to look on this database. The question was his improper purpose in accessing the database.
In fact, there was a case earlier that arose where another police officer in New York accessed the same computer system that they were allowed to, the police database, and did so, though, for an improper purpose of basically finding out information about this person and then putting it on the dark web. And there was apparently like a kidnapping plot that was the focus of this and everything. That particular police officer, because of the jurisdiction that they were in New York, I think it's Second Circuit, that particular police officer was found not guilty under the Computer Fraud and Abuse Act because he was allowed to be on that system in the first place. So that's what VanBuren's basically saying, right? VanBuren's saying, hey, me too, I was allowed to be on this, so why are you convicting me? And so this is what the Supreme Court has to decide, right?
That's exactly right. And there have been a number of amicus briefs that were filed by interested parties in the Supreme Court, among them the Electronic Frontier Foundation. And they point out the many circumstances under which a broad view of the statute that captures a lot of this other conduct and calls it criminal is actually very dangerous. The biggest example they use has to do with the fact that if a company has use policies for its employees about how they are permitted or not permitted to use their computers, what a broad view of the statute would do would essentially be to let those companies define the boundaries of federal criminal law.
Yeah, we've seen that. I mean, this law is supposed to be a shield to protect companies that we do, companies that we represent. It's supposed to be a shield to protect them, but sometimes it's used a little bit more like a sword, and that's kind of what you're getting at, that they could use this federal crime. So, for instance, in the oral arguments at the Supreme Court, somebody mentioned that if we all are on Zoom now in the age of COVID, if your company has its own Zoom account, a commercial account that the company is paying for, and you get on the account and you use it for personal purposes, maybe even improper purposes, but let's just say you're just catching up with a family member, that could be technically a violation of this federal law.
Well, that's right. That's the danger is really twofold. One is that it gives you this broad boundary of power for federal prosecutors, but also because under most circumstances, depending on the amount of damage you have, a private party can bring a lawsuit based on that claim.
Yeah. We've seen a lot of those in our practice. Yeah,
that's right. So, is a federal prosecutor going to send you to the pokey for having a Zoom call with Aunt Mickey? Probably not. But if the company is in a dispute with you about other issues, are they going to use that as a way of asserting a claim, gaining some leverage? Maybe.
Yeah, and the question then is, well, so now the Supreme Court has this in front of them. What are some of the ways that they could resolve this particular case? I mean, they can't. We know they can't write laws or rewrite laws. At least that's not really what their purview is. What are they really? What do you expect to see some of the options of what they could find in this case?
Well, if you look at the comments that were made during argument, a lot of the justices expressed frustration because the Solicitor General's office claimed that the definition was actually much narrower than the text suggests.
Yeah.
And what the justices were saying during argument was, we cannot rewrite the statute. only Congress can rewrite the statute.
Yes.
So what I expect is that unless the court is willing to accept that truly broad definition with all of its ambiguity, what they will do is they will find that it's impermissibly broad and that the statute's unenforceable as written.
So basically unconstitutional because it's vague, and when you have a crime, you have to fairly apprise people of what they can and cannot do before they can be convicted, right? So Officer VanBuren may very well have his conviction overturned, but this case is bigger than Officer VanBuren, right?
That's right. And it's one of a line of cases from the Supreme Court in which they have reinforced the notion that in order to be convicted of a crime, you really have to know very clearly that what you're doing is a violation of the criminal law.
Yes, excellent. Okay. Well, listen, great discussion, David. This is why our clients turn to you when there's white-collar issues. And we thank everybody for joining us for this edition of Real World White Collar Law. Thank you, and have a great day.